when you thought it was safe. Curriculum changed, PCP has gone and got a court case. It's proof for the deniers, revealing all the liars. UNESCO co-conspirers, stealing away your rights as a parent, a guardian. Remove your right to disagree. Chosen from the age of 3, exposing kids to CSE. Change the name to RSE, it's mirrored inequality. Legally made it mandatory, dictated by the GOV.
Hello everyone, how are you doing? It's been a long time since we've been live on this platform. So before we go any further, I just want to give a big shout out to Nigel Thorne, and I want to thank him from the bottom of our hearts. We're all deeply grateful for the way he's kept the platform going with his videos by gifting us his videos to stream on our platform. We've had some things going on in our own lives, so Nigel really has carried this platform on our social media for quite some time now. You know, I think it's been a good 4 or 5 months. So big shout out to Nigel. His work is invaluable. He covers an area we do not cover, an area that we are not well versed in. However, he's educated the country. It's important information, and that's why we believe it should be on our platform. So for those who don't know me, my name is Kim, and I am chair of Public Child Protection Wales. Public Child Protection Wales is an organisation we've set up. It does exactly what it says on the tin. We are the public protecting the children in Wales. And the reason why is simply because local authority, government agencies, non-government organisations and charities, local authority departments as well, they are not doing what they are supposed to be doing. In fact, they're going against everything. There's no democracy in this country. They're going against everything the parents and the people want. And we believe they are not doing an adequate job of safeguarding our children. So we're probably most known for our fight against the RSE. We are leading the fight against the RSE here in Wales. We've run a judicial review against the Welsh Government for their mandating of RSE, relationship and sexuality education. And during that judicial review, the Welsh Government lawyers successfully argued that parents' rights do not exist. That should have sent alarm bells all across the whole of the UK, because they used case law from Europe claiming parents' rights do not exist. We've only got parental responsibility. So you can understand why the media would have buried this kind of information. And that's what brings us on to our show tonight then. So tonight I'm joined by Darren and hopefully Joan. Joan is backstage sorting out her mic, and I do hope Joan can join us, because Joan is going to bring some, quite a different spin on this. We're going to discuss how these things are panning out in the classroom. So we've got Darren here tonight, and we're going to be discussing 2 things. We're going to be discussing the exemptions within the Curriculum and Assessment Wales Act, that's section 41 and section 42, how that can be applied, how that can be used. Basically, you guys have to take this information to your teachers and your local authority, and you have to educate them, because this legislation is new and nobody has read it. So Darren's become quite familiar with section 41 and section 42 of the Curriculum and Assessment Wales Act, and he has been supporting a family here in South Wales. A lot of you would have seen the exclusive this week. The exclusive went out from the Epoch Times, and it did reach TNT Radio and a few other platforms. That the Welsh Government has refused an exemption for a mentally disabled 5-year-old boy. And that actually got to tribunal stage, the Educational Tribunal of Wales. And Darren was a big part of that case. So no names are going to be disclosed, obviously, for, to protect people, guys. We got some brave parents out there, and we obviously want to protect the identity of the children as well. But everything said here tonight can be evidenced, factual. Everything we do is evidenced and factual. And this is the reason why Epoch Times could write that article and could keep mum and the child anonymous. So I'm going to hand you over now to Darren so he can explain a little bit about this section 41 and section 42 exemption. So this is the Curriculum and Assessment Wales Act, guys. And it's vital you all get to understand what's going on here. So over to you, Dan.
Good evening, everyone. So as Kim stated the Curriculum and Assessment Wales Act, as clarified by the Isherwood and Welsh Minister's case, Justice Stein clarified that there is no longer, although there probably wasn't a proper one anyway, there's no longer a parental opt-out for sex education, and in this case being more specific, RSE. So whereas in the olden days, if you so wished, you could request that your child was not taught sexual education, sex ed as it was when I was in school, and or religious education, those parental rights now have been abolished, in Wales at least. However, the Curriculum and Assessment Wales Act 2019 does contain, there are actually 3 exemptions. The one of them I haven't even touched upon, to the best of my knowledge, without running back and checking it on the legislation. It refers to children in prison, and young offenders prisons and stuff like that, and it's not something I've looked at. But section 41 and section 42, and just a quick disclaimer if I could as well, we are going to be delving into, at least to some degree, delving into legislation and case law in this. To make it factual, I must be referring to both case law and legislation. I'm not legally trained. This isn't legal advice by any means. However, the legislation and the case law speaks for itself. The judgment that we had from the tribunal, as much as we knew it anyway, the judgment from the tribunal, as well as the Isherwood case, clarifies that these exemptions are actually real. And the reason I point that out, as we get into the actual case that we've been fighting in the future of this video, we spent almost a year back and forth playing letter tennis and meetings and so on and so forth with the school and the local authority, and there was just an outright denial that there was any option whatsoever to take the child out. I mean, the English is pretty straightforward, but like I say, we've got these clarified now, legally trained or not. These are actually clarified in case law in the High Court and with the Education Tribunal. Section 41 first, which is probably going to apply less than section 42 because it's specifically for children with additional learning needs and individual development plans. So section 41, subsection 1. The additional learning provisions described in an individual development plan prepared or maintained by a local authority under Part 2 of the Additional Learning Needs and Educational Tribunals Wales Act 2018 may include provision, and it's A that we're most interested in, that disapplies sections 27, 28, 29 and 30 or any of those sections in relation to a pupil. Now, as with all legislation, anyone who's familiar will know that it just jumps you back and forth between different pieces of legislation and different sections and so on, so on. And I say that A is important, and to be specific, I will read 27 for you. So section 27 is the duty to ensure implementation of adopted curriculum. The head teacher of a school must ensure that the adopted curriculum is implemented for the school's pupils in accordance with sections 28, 29 and 30. So basically what that is saying in a nutshell, section 27 imposes a legal duty and obligation on the head of a school, and so any questions as well, sorry if I deviate, and Kim, you'll have to keep me under control, you know.
No, it's fine. If anybody has any questions about this, I'm watching the chat, guys, right? So I can only see the comments of people who've given StreamYard permission to comment. So if you have any questions as we go along, I'll try and ask some questions as well as from a parental perspective, and we'll see how we go.
Yeah, so Section 27 of the Curriculum and Assessment Wales Act imposes a legal duty on the head teacher that they must implement the curriculum, or at least the mandatory elements of the curriculum. Now, in Wales, one of the mandatory elements of the curriculum is RSE. So the teacher, which they will quite rightly quote back at you as often as possible, the head teacher has a legal duty to make sure that your child is taught RSE, and it's part of the curriculum. Now, what Section 41 does, and like I say, this is specifically aimed at children with additional learning needs and an individual development plan. So Section 41 allows the local authority, because generally speaking, they write the individual development plan for a child with special educational needs. It removes that legal duty from the head teacher. And therefore allow and technically the local authority as well. So basically, they no longer, if those sections are disapplied, or any of those sections, specifically Section 27, they are no longer under a legal obligation to teach your child RSE or any of the other mandatory elements. I mean, that could be maths or English. It's highly unlikely they would ever allow a child to be, it would have to come up with a reason why you wouldn't want your child to be taught maths and English, but it would apply the same as any of the curriculum. The curriculum can be adapted accordingly so that they're not taught the mandatory elements, and specifically what we're talking about, RSE.
Yeah, if I can just interject with that, as a parent, so before RSE came into become mandatory, I came in a little bit of a battle with the school over a mandatory subject myself. And I remember stating to them, it's the law for you to teach it and you to provide it. It's not necessarily law for the children to go there. I will deal with that side of things. So it is their place to provide these. And yes, by law, they should be providing it. However, if it's not appropriate, that is, it's not like a very serious issue. It's not like your child can't go to school if they don't partake in these lessons, It is not an impossible situation. And that was a situation before RSE, and it's just exactly the same for RSE now.
Yeah, and funnily enough, you mentioned a word there, which it seems to be the big word. Is written all the way through the code, through the guidance, through the legislation, and that's appropriate, developmentally appropriate. And again, I know Kim has done a lot of work on developmentally appropriate, and I followed early to some degree, but we kind of established certain things as well throughout the tribunal with developmentally appropriate, and at least the tools which are non-existent for assessing such things. So there are some conditions that must be satisfied before the local authority disapply sections 27, 28, 29 and 30, or any of those sections, which would, as I said, remove the legal duty from teaching RSE to the child. Section 42, it's very similar, but this applies to all mainstream children. There mustn't, in fact, be any additional learning needs or an IDP. The conditions are very similar, but basically Section 42, regulations may enable the head teacher of a maintained school or maintained nursery school to determine, in cases or circumstances specified in regulations, that sections 27, 28, 29 and 30, or any of those sections, are to be disapplied in relation to a registered pupil at the school during a period specified in the determination. So Something I must note, section 41, there is no time limit. If the local authority decide to disapply those sections in an IDP, although an IDP is reviewed annually, there's no legal time limit. So technically that could go on indefinitely for the whole time that the child is in school. Section 42, so it's a temporary exemption, or at least it's titled temporary exemptions. Now, when the regulations were written to accompany section 42. I can put all these links up in the chat as well. I don't know if everyone will see them then, will they, Kim? If I put links up.
Yeah.
Or they're available anyway. They're at least available on the PCP website. So the regulations, the same conditions must be satisfied by the head teacher in section 42 as in section 41. But basically under section 42, if the head teacher is satisfied, the head teacher can make the decision to disapply sections, the most important one, section 27, which removes her legal duty to teach the mandatory subjects, including RSE. Now, it said it's temporary. The initial disapplication would be for 6 months, and then either the child, and this is the thing, the child or the parent can request disapplication to the head under section 42. It's not just the parent, which then we delve into children's rights and so on and so forth. So it's a temporary exemption for 6 months, but then once that 6 months is up, it can be requested again and again and again. But after the first 6 months, then it becomes every 3, it's a 3 months exemption after the first 6 months. There are various conditions. So when you request it, like I say, it's the decision of the head teacher, although as we'll discover later, in our case at least, it wasn't the head teacher who made the decision. The decision must be made in 2 weeks. If the head teacher declines your request, the route to appeal, according to section 45, is through the governing body. So you would launch an appeal through the governing body. If the governing body favour your request, then they overrule the head teacher, and what the request to disapply sections 27 will be disapplied. We didn't get as far as appealing to the governing body for circumstances which will become apparent later on. So basically there are exemptions, as can be clarified with our experiences. We're by any chance not pretending that they're easy, although I do think that it's probably dependent on the local authority, and in the case of section 42, on the head teacher, how difficult the fight becomes will be dependent on the local authority and the head teacher.
So section 41, and just to clarify, that is for ALN children.
Yes, it is. Specifically, right, so, and only for, yes.
Okay, so parents of ALN children anyway, they are used to a fight. They're used to a fight. You've got all your documentation, you've got everything gathered up anyway, guys. You're in the same kind of game, right? You're in the same kind of game. You will get some people who support you, and you come across some people who will not support you. But you keep driving this through. If there's any chance that this could harm your child, or something can happen and your child will end up harming somebody else, you fight for them. All right? You fight for them, because prevention is better than cure. The local authority, the government, and the judicial might not recognise prevention, but we do, and we will wholeheartedly support your fight. We will promote your fight, and we'll always be there for you if you need to. Section 42 then, that is mainstream, yeah?
Yes.
So really then the Section 41 exemption would potentially 90+% of the time be applied for by a parent, because usually the parent is the additional needs child's advocate. But Section 42 also can be applied for by the parent, but children can also use this as well, guys. Children can use Section 41, of course they can, if they do have the capacity to do that. But Section 42 is for mainstream children. Wales is a country of children's rights, all right? Children's rights are law. Exercise those rights. Your children, we've had parents coming to us, we've had a 12-year-old forced into a lesson on porn. Statutory rape age that child is. And then she was also given detention for, what was it? I think it was preventing everybody's right to an education. These exemptions are there. Read up on them. The only thing that we do not have on our website right now is the what you've got there, the explanations.
Oh, the regulations.
Regulations.
Yes.
So the regulations, and what we'll do is we'll speak to Lou after this, and we'll have the regulations. And if you want a sex education on the website, publicchildprotectionwales.org, resources, you'll find the Curriculum and Assessment Wales Act. It's a massive document because that particular document is half Welsh, half English. You can just type in Section 41, type in Section 42. So underneath the legislation, then we will have the regulations, which is more of would you say it's more of an explanation of how these things operate, yeah?
To some degree, yes. So basically, the rules for which Section 42 must be implemented, basically. So they're just some extra rules.
Okay.
And that was specified in the primary legislation with regards to Section 42. Basically, is the section. So basically, I'll read Section 42(1) again. Regulations may enable the head teacher of a maintained school. So basically, they wrote the Curriculum and Assessment Wales Act, stating that the regulations may enable the head teacher of a maintained school, blah, blah, blah. Then the regulations followed up. So they wrote the regulations, which now do enable a head teacher to, and it's in the regulations where it states, you know, that they must answer within 2 weeks. I almost said 5 then, like it was in our case. That it states they must respond in 2 weeks, the time period. So it's a little bit more information basically than just the legislation. They're the regulations which actually legally allow 42 to be implemented. So they go part and parcel basically.
Right, so guys, I just want to say something. Guys, don't panic about this now. Section this, section that, regulations this, regulations that. You haven't got the confidence to do it. Your child might not have the confidence to do it. We will be, there's about 5 of us. We're individually going to be training you all on advocacy. For each part of that training, there will be a small PowerPoint on RSE, specifically Section 41, Section 42, lesson resources and children's rights. So we will bring all this in for you, okay? If you're lacking a bit of confidence, we can help you on that front. And I know this might sound a bit thing now, but we will put it into our presentations as well. And we are going to be banging it out from Easter right the way through, all right? So please don't panic. You can also take this video as well. It's available on the vlog page of the website, Public Child Protection Wales on Facebook, and it's also on PCP Wales on YouTube. So you might not see this straight away, but if you go onto our YouTube channel, click live videos, and then you'll definitely see it there, okay? So anything you don't understand, please come back to us. And like I said, we are going to be... We're going to be doing everything we can to give you the confidence, the knowledge, and everything you need to get out there, educate our country, and find the people that's going to stand up for our children. Sorry about that.
Yeah. No, that's great. And just to go a little bit further with that, like I understand totally. You know, when you're going through legislation and stuff like that, it can be very daunting. And, you know, I'm trying, without going too deep, I'm trying to explain it kind of in layman's terms, but to put it as simple as I possibly can. And this is in confidence. Section 41 is an exemption for all children with ALN, but it's not a parental exemption, you must seek permission. And section 42 is an exemption for all mainstream children. Again, it's not a parental exemption. We must seek permission for that. But these are two genuine bona fide exemptions which exist in legislation and in law. So excusing the technical jargon and actually reading specifically from them, and I've only touched on the very first part of it. There is a little bit more, and there are conditions to be satisfied. But again, you know, the team with PCP, any questions, queries which need answering can be answered. We've been through this. We know the arguments basically, and something else a little bit more positive. You know, we've tried and tested now. We know the arguments that they're going to throw. We've got the answers for those arguments. And again, that still doesn't guarantee a success. But, you know, we were kind of, with the case that we've just gone through, we weren't sure where it would go. We weren't 100% sure on whether these were genuine, legitimate, legal exemptions, but we can now affirm 100% guaranteed that they are, regardless of what the school or the local authority might tell you, they are. But unfortunately, you need their permission for it instead of being able to do it yourself.
So somebody's just comment, what happened to Diamond still supporting? Absolutely, Mr. Diamond, this stuff is below his pay grade. He is there. He's there, and also Bruno as well, guys. You know, we do have the People's Barrister on side, but it does take a lot of work, you know, on the run up to these things. You have to meet a certain criteria, like Darren said. You know, that it's what you say was paper tennis, letter tennis, yeah. So there's a lot of work to do before you get to these stages. With the sex education against the government, it took us 2 years before we actually filed a letter before action. So you have to tick these boxes and you have to fight. And before we move on, I just want to say something as well, because you said certain conditions need to be met. If your child is feeling insecure, uncomfortable, doesn't like these lessons, doesn't want to be there, the best thing you do, you take your child to the GP. Because that's something we keep coming up against. Like I said at the start of this video, we are trying to prevent things. LA government and the judicial is not accepting preventative cases. They want to see a damaged child. All right. Now, the best way to achieve that without damaging a child is to note your child's anxieties, note your child's uncomfortabilities, take your child to the GP and get it there, guys, right? This is the only way we are going to be able to prevent damage and provide the evidence, all right? So your GP, take it to your GP, speak to people, get everything on record, everything on paper, email, any support you need from us, we are here. And I do, before Christmas as well, Darren was really fantastic. He made himself available once a week in the evenings for Zooms, and that kind of fell down then for Christmas. But we can do that again. Darren's massively busy. Maybe if we did fortnightly or whatever, that's something we discuss off screen. So does there anything you want to say before we actually come on to the Education Tribunal?
Just briefly, and I am sorry for droning on. But what I would like to say, and again, in my experience, if anyone is up for the fight, this was my first tribunal. I've been through the county courts and I've been through the magistrates' courts. I actually represented the mother in the tribunal. It was my first tribunal, and genuinely, it was as much as it can go. It was really nice. You know, in my experience, the county courts, just being in the waiting room is a dark environment. It's not very nice. Do you know what I mean? But the tribunal, in all fairness to them, as much as we didn't get the result that we wanted, the judge was very nice, very jovial. It's a panel of 3. It's not like being in court, basically. So don't feel daunted by the process. Yeah, I just, that's it basically. It's not quite as bad as the courts is the picture I'm trying to put over. They're very much there to, or at least they try to make the parent welcome and comfortable, and there's no stress, there's no aggro. It's as much as it can be, it's a pleasant environment. So don't be put off by the process if you think if you need to go.
Just for a bit of a confidence booster for the people listening to this who don't know who you are, you've spoken a lot now about legislation. You sound like you know what you're doing. Can you let the people know what your actual occupation is?
Oh yeah, I'm a landscape gardener, basically.
See, guys, and this is really important. You understand this. These ordinary people doing it, you know?
That's it. We're all ordinary people. Yeah, I work and look through circumstance, and this isn't the time or the place to bore you with the details, but I sort of dip my toe in the realms of law, and it's a bit of a hobby now. And generally speaking, once you learn how to read and how to find your way around the legislation, it does actually become quite easy, to be honest. And the solicitors and the barristers, they're just people too. As long as you can read, then it's fine. Like I say, don't be daunted. And there is, there are people on hand, PCP for a start. There's a lot of information on their website. So yeah, and at the end of the day, I know Kim keeps banging on about it. These are our kids, and if you have to spend extra half hour reading a couple of extra documents to bring the fight, then in my opinion, it's most certainly worth it.
Yeah, so, and you've got the support as well from us. So, and then that brings us on to the exclusive case of the week, story of the week. It became an exclusive in the Epoch Times. We have had some people complain about that online, so I'd just like to address that now before we move on. The Epoch Times is actually the only media outlet who have reported accurately on our case. I do know that if you do a Google search, it'll come up the far right and they're not credible. We can only speak from experience. We are the people who give the interviews. We are the people who provide the evidence. And we're also the people that usually get articles written about us, not in support of us, false information, twisting things. And, they don't give you the full facts. I think we are the best judge of who writes a fair article, And in current climate, with BBC, ITV, Channel 4, the way they are, at the end of the day, beggars cannot be choosers. And we are grateful for anybody who will take the story, and we're even more massively grateful for the ones who report accurately. And that is the reason why we're here today discussing this now. We did hit the media with it. I know David Curtin picked up on it on TNT Radio. This is a massive story, and I think everybody needs to know how this goes on. So Darren has explained a bit about these exemptions, how they applied, who you applied to for them and everything else. But Darren is now going to explain, what's been going on the last year, Dar. Let's start from the beginning. You've been supporting this family all the way along, and it's taken a year to get to this stage. You tell us exactly what's going on. Tell us about this family.
Right. From the very beginning, I must say I was not involved. The mother started in about March last year, so it's pretty much spot on a year ago. I believe her first request was either the 3rd or the 5th of March, 2023. Forgot what year we're in. So it's about 13 months technically. I got involved with her. She was facing a brick wall. What she was requesting was technically Section 41, although she didn't know it. She got put in touch with me in about June, and that's when I started helping basically with the paperwork. Hats off to the mum as well. Absolutely, she made my job so much easier. She's documented everything. She's got every single email, every letter, every correspondence. From the moment I got involved with her, she ended up recording everything, and that was a godsend. we would have been shafted a lot earlier if she hadn't been recording everything. And I'm talking meetings. Now, just for a bit of information, people might be unsure on things. There is no law against recording public servants and teachers, local authority employees. They're all public servants, and so while they're acting in the duty of their public service job, there's no law against recording them. Obviously, putting a camera through their living room window while they're eating their tea would be slightly intrusive and probably massively illegal. So you can record them. Now, the situation that we were in, and I say we only because I got so involved, you know, it was 8 months of my life basically, and it's quite personal to me as well now. The little lad, he's a lovely little lad. Anyway, we were recording pretty much most things covertly. Now, there was some objection to recording covertly when it got to putting evidence into the tribunal. And if I call it court, I do apologise. If I say court, I mean tribunal. So first of all, we had them transcribed. We put them in as evidence. Initially, they were never recorded to be evidence in the tribunal. But the lies and the cheating, basically, they were a requirement just to make sure that the facts stayed correct for the hearing. And what you've got to understand, there was mum. While I was just doing the paperwork, nobody knew I was involved until I actually represented in the hearing. As far as they were concerned, it was just mum. And all of the different departments, and when I say all the different departments, the school, the local authority, Central South Consortium for Wales, and even the Welsh Government are involved or got themselves involved. And they all buckled down and gave the same story, basically. So, like I say, for the right up until we got to the tribunal, or at least till we got the tribunal hearing accepted, there was a continual refusal that this was even possible. Now, given the benefit of the doubt, I do believe in the beginning, most likely because this legislation is so new, and given the benefit of the doubt, I do think that probably most people genuinely believed that there was no exemption because it is classed as mandatory all the way through. Right, so that's the case file. So I'm just going to be reading a few bits and bobs just to point out what we were up against. So when we first put our section 41 request in, the response that we had back, the legal, right, and we waited, good gracious, it was weeks and weeks and weeks and weeks and weeks we waited for this response. It was only when we actually put in a formal complaint that within a day or two we actually got any responses back. We just kept waiting and waiting and waiting. I can't remember the exact figure. I could find it too, but I'll just be wasting time. But the response we received, the legal advice in relation to the RSE curriculum confirms that the Education Tribunal for Wales does not have jurisdiction in relation to this curriculum. It only has jurisdiction in relation to the additional learning provision to be provided during RSE lessons. The RSE curriculum delivered to young boy will be relevant to his cognitive profile. Following legal advice, we've amended the following statement in his IDP form. I mean, that's just utter nonsense. The Education Tribunal for Wales, it was just nonsense. And we told them it was nonsense also. That was the section 41 request. Now,
If before we go any further, can we just explain this little boy's condition to people?
Yes, of course we can.
He's just turned 6, so he was 5 throughout all of this, yeah?
He was 6 in January, so dealing with, and the tribunal hearing was actually, or the main tribunal hearing was actually the 29th of February, a leap year. So he was, at the time of the hearing, he was 1 year and 1 month old, basically. So throughout all of this, he was 5. Yeah, so when Mum started, he had literally just turned 5. So he is autistic. He has dyspraxia, ADHD, and he is also peg-fed through a tube. Now, the significance of the feeding through a tube, there is nothing mechanically wrong with him at all. It's a psychological issue. His psychological issues are so severe then, from my point of view, that he will, and almost did at one point, literally starve himself to death instead of putting food in his mouth. Now, to me, that's pretty severe. As mental illnesses go, to me, that's pretty severe, that you would actually starve yourself to death. That seems to me to be a standard human response, that when you're hungry, you eat. You understand that you need to eat to survive, but he will literally starve himself to death. Like I say, he's a lovely lad. What's that, sorry?
Why has he just stopped eating?
Well, as far as I'm aware, is one day he just decided that he was scared that he was going to choke, and hasn't put food in his mouth since. He will lick what sits, but that's it. He won't actually put food in his mouth, crunch it up and swallow it.
So this is just something that's psychologically...
It is something psychological. None of the experts who've evaluated him understand why. So there are various treatments. Oh, sorry, I dropped my pen. Not a treatment in the sense of a medical intervention, a pharmaceutical or something, but psychological work. They're trying to cure this psychologically, but so far to no avail. None of them know why, and so on and so forth. When is dyspraxia. So, and again, this is one of the reasons why the gender ideology and topics of that nature are of concern to us. When he becomes dysregulated, and I'm using the technical words used in the report by his occupational therapist, when he becomes dysregulated, he believes he's a cat. Now, there was also the legal team of the local authority made some bland attempt to play that down, unfortunately, even though they're not medically trained. But that he so believes that he is a cat that last year Mum had to go out and throw a birthday party for Sally the cat, where it cost her 35 quid. She had to buy a cake, balloons, and even a present for Sally the cat. The young lad truly believes he's a cat when he's dysregulated, regardless of what the local authority's legal team claimed in their non-medical expertise. So yeah, like I say, again, in my opinion, I'm not medically trained either, but in my opinion, that strikes me as somebody who's got pretty severe mental issues, to be honest, psychological issues. So we had, like I say, we had a response from the Section 41 request, which was utter nonsense. It didn't make sense. It took me some time reading that over and over again. And I came, so in my mind, that left me with various possibilities. A, they were trying to fob us off. B, that the legal team had misread that section of legislation so badly that they don't deserve to work in a legal team, to be honest. And that's pretty much the, you know, to come up with that response. It was nonsense. There's no other word for it. And when I quoted that in the case file as well, there was no rebuttal of it being nonsense. And it was only when they submitted their case file, I believe it was either the November or the December, I believe they submitted their case file. That was the first time they actually admitted that that sections 27, 28, 29, and 30 can be disapplied. That basically that was their first admission that section 41 and section 42 were actually real things. Up until then, we'd received nonsense. Now, the conduct of everybody involved, I think, like I say, you know, we've spoken about the legislation and the law, and there are various bits that I can clarify that these are real things, including the judgment. But obviously, I can see we're on 45 minutes. I don't know if I can go through now and just point out some of the issues that we had facing in this.
Yeah, well, I think it's important that people understand what Mum went through as well. And the thing is that this video, anyway, it's going out in one video, but I'm going to cut it later on, so I'm going to split it. So the second half is just going to be the case. The first half is going to be about the legislation,
right, okay,
separately. So okay. you got for about 25 minutes.
All right, I'm just aware that I can waffle on and. Yeah, I'm just aware that I can easily waffle on and just kill 30 minutes of that for talking nonsense. So, right. So we've got. All right, lovely job. You might need to. So we've got an email here, and like I say, you know, we there's so many documents and pages went in. Some of them are just your usual, but here's an email here, for example. From the local authority.
Sorry, I've got to interrupt because we missed something massive here.
Go on.
We've missed something massive here. Mum did get the exemption.
Yes, she did. Okay.
So Mum applied for the exemption and it was given to the child, wasn't it? He was exempt from RSE.
Yeah, so on the 23rd of May, 2023, there was a virtual meeting, or at least some of the people were virtual on there anyway. There was a meeting, there were various parties. There was a couple of teachers from the school, the ALN coordinator from the local authority. I'm being very careful now. I'm trying to remember their titles as opposed to stating their names. His occupational therapist. There were a number of people on this case anyway. So what I need to do now, and again, I mean, I would have come to this point anyway, because it just points out how ridiculous, basically, their responses were, to be honest. So the notes from the meeting, again, it was a social worker who was taking the notes from the meeting on the 23rd of May. And it states, amongst other things, but it states, agreement for young lad to be removed from RSE lessons. Local authority ALM woman and occupational therapist, obviously it's the names in here, advised this was appropriate due to young lad's developmental needs and behaviours that he displays, such as being a cat. Occupational therapist believes this behaviour of becoming a cat occurs when he becomes dysregulated. School agreed to write that young lad is to be removed from RSE lessons in IDP and mum to attend school next week to sign the paperwork. Now, if that's okay, I just want to read that again, because to me, that's pretty specific. That's difficult to misinterpret or anything, right? So, agreement for young lad to be removed from RSE lessons. Local authority ALM woman and occupational therapist advised this was appropriate due to young lad's developmental needs and behaviours that he displays, such as being a cat. Occupational therapist believes This behaviour of becoming a cat occurs when he becomes dysregulated. School agreed to write that young lad is to be removed from RSE in his IDP, the individual development plan, and mum to attend school next week to sign the paperwork. Now, again, in my opinion, I find it difficult that somebody would just note that stuff down without ever hearing it.
Yeah,
you
and
know,
that sounds pretty legit, Di. You've mentioned there ALN, the inclusion woman from local authority. You've mentioned their occupational therapist. You are mentioning people who are professional and people who have been around the child.
Yeah.
And that is in their professional opinion that he should be removed. The legislation supported that exemption. It should be job done. Yeah?
Yes, yeah, of course it should. Right. So, in their case statement, paragraph 24, it is correct to say that social workers' case notes of the meeting states agreement for blah, 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 and they've just quoted what I just read to you. So it is correct to say that she did write down her case notes. However, paragraph 25, however, the local authority do not consider this to be an accurate note of the meeting for the number of reasons. A, the note is not a full minute. B, the school could not have agreed for a young lad to be removed from RSE lessons as the local authority were responsible for preparing and maintaining young lads' IDP. And 3 is irrelevant anyway. So the person at the meeting who advised it was the co-author of the IDP with the school. So that's B out of the way, but they're saying it's not accurate because it's not a full minute. Now, again, in my opinion, any dealings I've ever had with a local authority, whether they're coming round to look at a leaky tap on your council house, whether there's a hole in the road, whether it's social services, whatever you talk to them about, they take notes. Very rarely do they take full meetings. Have they got an actual minute taker? It's always full notes. So what they're saying there is all the notes taken by the council are inaccurate unless they're full meetings. And that's how that was accepted as an excuse as well, basically. So that was their excuse for getting out of the social workers' notes where they actually agreed. He was taken out for 2 weeks. We can evidence that he was taken out 4 weeks. To some degree, they actually admit it in their witness statements. Then their denial in their witness statement of not taking him out. It's a load of garbage, basically. What that proves is they contradict themselves, and what they prove is he was taken out for 2 weeks, and then the lessons which occurred after that 2 weeks, he was included in. So they're clarifying our version of events, basically, in an attempt to disprove us. But
so
again,
everything went right then. Mum did the right exemption. The right professionals were involved. They said this was okay for his IDP. He was rightfully removed from his license for 2 weeks. Then what? They just said this didn't happen?
Well, then there was a reversal, basically. The deputy head teacher basically informed mum that they would no longer be. They've received advice from a higher source. I believe that this is one of the few things that we haven't got documented, other than in an email exchange where it's not quite as clear as what mum remembers. But she can specifically remember being told that it was somebody higher up in the education department has advised that they're not allowed to do it. It turns out that it wasn't somebody in the education department. It was actually the Central South Consortium for Wales who gave that advice, and they took their advice from the Welsh government. It went right up the chain to the education department in the Welsh government, to be honest.
So basically then right the way up now to for him being removed from RSE, that was all legitimate. Everything was great. The legislation was there for that thing. It was appropriate for this child. And then orders from above came down from somebody who's never met this child.
from somebody who's never met this child. And funny enough, a lot of these people have not met this child. A lot of people who got involved. And you actually said a word there, legitimate, and we'll swing back now to law. So legitimate expectation. If a public body unambiguously make you an offer of something, and obviously there are conditions, they must be legally entitled to make the offer and so on and so forth. It mustn't be in breach of public interest and so on and so forth. But in a nutshell, if a public authority, if a public body offers you something unambiguous, and you unambiguously offer you something, and you rely on that offer, they cannot take it away from you. So technically, in law, we won the case. That's why they made up their garbage excuses that a note is not a full minute, because the legitimate expectation won us the case in law. They couldn't admit that was stated. Basically, that's us done. We'll forget the rest of it. Forget the tribunal. We're done. We've won.
Yeah.
So they had to eliminate that legitimate expectation, and that's why they gave the nonsense excuses for the meeting notes not being accurate, because they weren't full minutes, etc., etc. So that's the reasoning for that.
So what they did then was, to simplify for people, they pretty much said the social worker's involvement was not right. Oh, was not accurate.
Oh, right. So although she was a social worker, what her actual role was in the meeting, we don't really know. But she was the person. She was the only person taking the notes in that meeting, and they even said that the notes were taken the following day, right? And that's another reason why they were inaccurate. But Mum only knew the notes existed, and she didn't get them until quite later on in the case. She knew the notes existed because she was sat opposite watching her take the notes. So it's not, so basically we're not quite sure of the role of the social worker in there. She might have just been an observer. That could have been her only task, was taking the notes. But what their point of view is, the notes are not accurate. Nothing to do with the social worker or the fact that she was a social worker or anything. They're just stating that the notes she took are inaccurate for the reasons that the nonsense reasons that they gave.
So one of the professionals involved then was inaccurate. So wouldn't that apply to all of the other professionals involved then? Well,
you would think so. You would think that all of the notes of the local authority are inaccurate, because none of them are full minutes. They didn't present anything which was actual minutes. They were all just notes, as is generally the case with everything. Again, it's clearly obvious that was just a nonsense excuse, because they needed to eliminate that legitimate expectation. That was a win all day long, basically. They needed to get a shot at that, and the legal team knew it, and that's why they wrote the nonsense excuse.
Can you hear me?
Yes.
Yeah.
Okay. I was just thinking that the fact that their system has, in a way, been corrupted somehow or other, either voluntarily or involuntarily or whatever, a mistake has been made. Why wouldn't they just hold a second meeting in order to clear all that up?
Exactly. Yeah.
Good question.
Exactly.
That's a good question, John. But that's another thing. And we got all these. They should have been legal up to the point where they withdrew him anyway. After that, I think that's what led then to tribunal, wasn't it?
Yeah, basically. So, I mean, on the same topic, or at least a similar topic, the Welsh government's response. So while all of this was going on, and as I mentioned previously, while we were waiting we waited weeks and weeks and weeks and weeks and weeks and weeks and weeks for the legal team to get back to us with the Section 41 nonsense response. In the meantime, we put in a Section 42 request to the head teacher. We didn't know how it was going to work, because obviously Nikki has got ALN and so on and so forth. at that point in time, I hadn't come across the regulations, which we spoke about earlier either. So I was sort of unfamiliar with the specifics, but we put it in anyway. And we put it in specifically just to safeguard, him while we were waiting for this response under the section 41, which was already taking forever. So mum kept querying, where's your response, where's your response? And again, at this time, because we didn't have the regulations, we were unaware that they had 2 weeks to respond. They actually took 5 in the end to respond. And again, we only got the response when we threatened with a formal complaint. Now, we got a bunch of emails through subject access request, basically. We got a bunch of emails back, basically, of the head teacher in the 11th hour after we had threatened with a formal complaint. She puts an email out to various people in the local authority and the governing body and so on and so forth, requesting advice and assistance on how to answer mum. It was clear to her, obviously, by this time. I can't obviously, read her mind, but it appeared clear to her by this time that we weren't messing around and she was going to be complained about. Anyway, the response which came back originally, because when you do a subject access request, the names are pretty much always redacted. We had an email anyway, which was basically tell mum this. And we know that the head acted on it because she pretty much copied and pasted that sentence into the letter, which was basically, we can't disapply sections, blah, 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 because we have no legal grounds to do so. Anyway, it turns out through some coincidental and random series of events, but a mistake on their part, that we received the unredacted version of this email. And up until that moment, everything was fine. The legal team had said, look, we've got no legal grounds to do so, although we disagreed. We got no legal grounds to do so. Anyway, it turns out that legal determination, as copied and pasted by the head, was not made by the legal team at all. As far as we can work out with all of the documentation that we've got, she never even put it to the legal team to give us a legal response, although that's what we were being told. That determination was made by the head of governor support, an employee at the local authority, basically, which, if I'm correct, is an offence. I mean, I made a disclaimer at the beginning that this is not legal advice. When I talk to Paul Diamond, for example, he will always tell me this is not legal advice. And he is a barrister. He's a top barrister. And he will always tell me this is not legal advice. You probably see it because under I think it's section 12 of the Legal Services Act, to make a legal determination such as this person did is illegal. And that was what was portrayed to us. And then it goes further then that the Welsh government, as I said, I've actually got the email here. So this comes from, so by this time, the head and the local authority, it would appear, had been in touch with the Central South Consortium. Now, the Central South Consortium, they seem to be a consortium of people put together by, I believe it's 5 different local authorities in Wales, just to give advice on the curriculum in particular. They offer tools and videos and so on and so forth, and advice on the curriculum. There are already some other dealings in here which are a bit shady, but this email was sent to the Central South Consortium. The chain of emails, etc., that we've got, the Central South Consortium had obviously gone to the Welsh government requesting advice on our request. or requests, because they address section 41 and section 42. This comes from the Education, Social Justice and Welsh Language Group at the Welsh Government. And basically the first paragraph is a 2-page document. The first paragraph: apologies for the delay in replying. I've been out of the office. We would prefer, as far as possible, to be quoting from the 2021 Act and Justice Time from the Isherwood and others case. And this is where it gets really good. Getting an exemption via section 41 would be an extremely rare, and therefore we want to reflect this. Suggest the following lines below instead. Right, so instead of telling us that you can, but it would be rare, blah, 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 they said suggest the following lines instead. And then they just run through all the parts where, so I'll give you an example. The Curriculum and Assessment Wales Act 2021 expressly provides that RSE is a mandatory element of the new curriculum. The Act repealed the pre-existing right to withdraw from the subject of sex education and does not include a new right to withdraw from RSE. And there's 2 pages basically of text like that, which would give the impression that it's mandatory and there is no exemption. So that there is a cover-up. When they and that went to the Central South Consortium, and we can also prove that the Central South Consortium also passed this information on to the head teacher in October. So from October, the head teacher knew that the young lad could be withdrawn, but instead told mum the other rubbish instead. And when they're talking about section 42, they massively misquote your case, in fact, Kim, in regards to it being 1 hour a week for a piano lesson. And the relevant paragraphs in that case law are, in fact, paragraphs 98 and 132, I believe. So they it's not quite a lie, because RSE is mandatory, but they specifically say use these lines instead. In other words, keep the truth from mum. And when it comes to section 42, they actively, I can only believe it was intentional, but who knows, but they massively misquote your case law, massively misquote it. So it looks like the section 42 is non-existent. We have an email here this is from the Strategy, Community, Learning and Resources section of the local authority in question. And this one I think is disgusting, but it sets out the tone. Right, it's very short. So it's basically, I don't know if you can see that, it's literally two lines. And basically the second sentence is, hopefully continued discussions with mum will make mum see that such an approach is frankly pointless. Bit frustrating that the Welsh Government have pointed her in this direction, as it's likely to waste everybody's time.
Right, before we go any further, read that one more time and then go through Nicholas' condition.
Yeah, okay. So hopefully continued discussions with mum will make mum see that such an approach is frankly pointless. Bit frustrating that the Welsh Government have pointed her in this direction, as it's likely to waste everybody's time. And when we're talking about this, we refer to this as the frankly pointless email. I mean, that, in my opinion, is an absolute disgraceful and disgusting point of view to have from any local authority, particularly because all the way through this, she was right. Our argument was correct. We are right. She's trying to protect the well-being, the safety and well-being of a 5-year-old mentally disabled boy. And that is the kind of email that they're emailing to each other. And that was between the school. There's two, again, we haven't got the names, but we know there's two to the school, 2 people in the school. So probably the head and the deputy head. And they were CC'd into the Central South Consortium, and it was to somebody directly to the Central South Consortium. So they were all conspiring, look. We've got another email.
Go through the needs of this child again now, because this is frankly pointless. This is what's frankly pointless. Go through those needs of that child one more time so everybody can hear.
Right.
What
So
is frankly pointless?
yeah, he's autistic, he's got ADHD, he's got dyspraxia. When he's dysregulated, he truly believes he's a cat, and his psychological issues, in my opinion, are so severe that he will not put food in his mouth. He would literally starve himself to death instead. And he has actually been in hospital where he almost died on more than one occasion, particularly in the beginning before the tube, because he would not eat. You know, it's not something that if you leave him long enough, he finally will put something in his mouth. No, he nearly died.
So he's almost, this child has almost starved himself to death over a psychological thing that's kicked in that no medical profession has gotten to the bottom of.
Nope.
And mum's attempts to remove her son from something that could potentially harm him, which we know does harm because we've seen it around the world, right, is frankly pointless.
It's frankly pointless. And, you know, it's frustrating that the Welsh government pointed her in their direction because it's likely to waste everybody's time. It's just a waste of time.
Can you imagine how that mum felt in that moment? This was written about her. So this was written about her. So can you imagine how she felt in that moment when she read it? She wasn't supposed to read this. She's being told her fight to protect her child is frankly pointless. Her child is frankly pointless.
5-year-old as well. And again, you know, this is the power of the subject access request, basically. In case there's anybody who doesn't know what a subject access request is, they can be massively powerful. They can still shaft you as and when need be, and therein lies another story as well with this case. But basically, you can request your data, and data is obviously documents, photographs, videos, telephone calls, contracts, whatever it might be, anything which identifies you, so your name, your address, anything like that, you can request, and they are legally obliged, with the exception of some exceptions, to provide all of that data to you. Since 2018, they are now free. They used to cost you a tenner, and they take about a month to come. In this case, they claimed, they claimed hardship or something. We ended up waiting through 4 months. They added an extra 3 months onto the subject access request on top of the month which they should have been allowed. And we ended up getting the documents just a few days before our case statement had to be in, or the final deadline for our late evidence in January. So they can play games with you, but they're massively powerful tools because you discover things like this. You know, that's what they think of us, basically. And in this instance, I mean, I say us, you know, I'm a grown bloke, but this is referring to the mother of a 5-year-old mentally disabled child. Frankly pointless. Like I say, I think that's disgusting and disgraceful, and there's no excuse for that.
Just a bit of mechanics, Darren, for anyone that's never done it before.
Yeah.
So you have to title your letter subject access request or your email, and then what do you say? Do you say every little bit of evidence, whether it's this or that?
There are, right, so technically, once you put in a subject access request, technically they are supposed to give you everything. When I write them, I tend to add a few more specifics in. And again, just being pedantic, I write in and on file, just because if they wanted to be funny about things, they might have a little post-it note on the front of the file, but because I've said in, they might not include that. Do you know what I mean? And that's just me being pedantic, but it's good to be specific sometimes. There are 1,000,001 templates out there. I used to go overboard when I first started doing them some years ago. I used to go overboard with them and have all of this stuff in there, but you don't need a great deal. It is good to have, if you're looking for something specific which you know exists, then it's good to actually note it in there, and then there's no excuse. And again, they can come back. There's a process with everything. So you do your subject access request. if there is any information which you believe exists, or if you better if you know or can prove it exists and it's not included, then the procedure is, I believe it's 30 days, but you have a time period to go back to the person or the organization, tell them what you were expecting, which is missing, and why you believe it exists. Then they have another 30 days to get back to you. If it's still not in there, then you can go to the ICO. If you go to the ICO before giving them a second opportunity, the ICO will just straight refer you back to them. Again, the ICO is a governmental body. They do make some good results sometimes. It's not all lost, and even if they were to investigate and you don't get the result you're looking for, once you've got that reference number, if you go back to the organization or whatever and say that you've been reported to the ICO, they very often find what you're looking for.
Yeah, that's usually enough, isn't it?
Yeah, it is usually enough. And like I say, there are occasions where the ICO really do pull their hat out of the bag and pull off a miracle job for you. Not always. People still get shafted. It's the government. But yeah, it's worthwhile, but you must follow the procedure. And like you say, there are 1,000,001 subject access request templates online. You are right. One of the minimum requirements is they must be aware that it's a subject access request. So the title on the top. In recent years, what I've noticed is if you're doing them on like local authorities and so on and so forth, they will ask you for ID. That's basically in the interest of protecting themselves from any further data breaches. Basically, if they gave that information to the wrong person because they haven't asked for ID, then obviously they're liable. There is there's a couple of criminal offences, not many, but one of the criminal offences in the data protection.
Guys, sorry guys, we have to stop on this. I have to stop on the subject access now. We talk about the ICO another time. That's not important.
Okay, sorry.
We need to end on developmental. We need to end on developmental because I've only got 4 minutes left on storage. So developmental. Right, okay. We need to address this quickly, guys. So sorry to cut you off, and you told me to.
No, that's fine.
Yeah, this developmental thing is really important because we keep getting told this is developmentally appropriate. So, Da, if you could just explain a little bit about how that played out in the tribunal. Yeah. And then, Joan, if we can pass over to you then, because you are a retired teacher who has dealt with children with different developmental needs. And like you're an RSE teacher trainer as well. So if we could have just a bit of input then from you, Joan, about how this can play out in a classroom, the practicality of it, that would be fantastic, guys.
Right. So very, very briefly, it was already established in your case that there were no tools to assess developmentally appropriate, which is one of the conditions when teaching RSE. It must be developmentally appropriate. All we can see at the moment is that it's age appropriate, split into 3 age categories, if I remember rightly. We did freedom of information requests on them, and we even presented it throughout the tribunal that there are no tools. They kind of implied that there was through the Central South Consortium, but when I cross-examined, that turned out to be rubbish as well. There are no tools for them to determine what is developmentally appropriate for any child. The tools do not exist. It's basically down to what the teacher believes at the end of the day. And because we've only got a little bit left, over to you, Joan.
There we are.
Oh, thanks so much for all that, because even though I'm familiar with the case, there's still an awful lot, isn't there? But the overpowering thing for me is, even if I saw this black and white on paper and heard the outcome, I still wouldn't believe it. I would never in a million years have believed that such a thing could come to pass. That a child that is so vulnerable, that is so deeply affected in so many different ways. And he's vulnerable in the sense that he likes to please other people as well. And that could go very badly for him, couldn't it? For example. And the way that they're trying to implement the actual lessons on his behalf now is that Well, it was suggested, wasn't it, that he might be retracted to a different area of the classroom, for example.
Yeah, that was in the judgment. But again, it was also established during the hearing that he's still in, to quote them, he's still in earshot of the teacher teaching the stuff that isn't
Exactly.
appropriate for him to the rest of the
Yes.
kids. So it's a pointless
Yeah, and of
exercise.
course that they're going to probably be having stuff on a screen. They're going to be having activities and songs and things like that. How could he not listen? How could he not
Exactly.
overhear?
Exactly.
And
Exactly.
then what worries me is the idea of confidentiality and the way it's being used in schools in a very inappropriate way. The fact that the word confidentiality is brought it is beyond the comprehension of children, really, or it ought to be. It should not be encouraged for anyone in a primary school, or I would venture to say up to the age of 16.
Well,
To
that's
be
what
honest,
groomers use, isn't it?
to be
Yes.
yes, and I found that highly disturbing that the child, for example, was told in one lesson that what was said in the classroom should remain in the classroom for whatever reason. Because even if they wanted to use other children's stories, whatever those stories are, the point is that that could be done in an anonymous way if they wanted to, especially if they were asking personal questions. And everyone has to remember that with RSE, it does get very personal. And that's the whole point of it, because it's directed at a child. It's directed at a child and at a child's family. So they will ask intrusive questions, and they already have. So the confidentiality didn't go well with this child, did it? Because
No.
he instead he took it literally, and this is the problem.
Yeah.
He's going to take everything literally. He can't do any sifting through facts. He doesn't have any grey areas. He's going to go extreme on anything that is told to him. So he was told not to spread what was said in the classroom for whatever reasons. I don't know whether they were legitimate or not, but it's very worrying that that should have been said in the first place. So the fact that he was told that, he took it literally, and by now he is not sharing information with his mother about what goes in school.
Exactly.
Which is a massive concern, because we do know children are harmed in school, and 42% of children being harmed in school are aware of it happening to other children. And that's just in mainstream school. Children of these needs, again, are 4 or 5 times more likely to be harmed. And what is the number one thing we tell children? No secrets. Why? Because we know that's what predators do. We are playing into the hands of predators, and it's the most vulnerable in society is going to suffer with this, Guys, I don't know if you want to end up saying something quickly, because I thought we had 1 hour 19 in storage. If you want to say something quickly to end off, that's absolutely fine. So do you want to finish up?
You want about me?
Anyone?
Yeah, I'm just going to follow up on what Joan was saying with regards to confidentiality then, just to give a bit of clarity. Specifically, we were referring to the Jigsaw curriculum. Now, if you go on the internet and look up the Jigsaw Charter, it's like a little picture scroll, and there's a number of items on there, and the last one is confidentiality. Now, Mum actually brought up with the deputy head that she had an issue with the confidentiality section of it. We've got it recorded. That recording wasn't actually put into the tribunal as evidence. We have got it on recording, his remarks, and he laughs it off, and we're not teaching the kids about copyright law, not at this age anyway, and he makes a joke out of it. So they went ahead, taught him confidentiality. Since that time, he hasn't told his mum anything that goes on in school, which she's obviously gutted about. During the tribunal, this was obviously brought up as evidence, and the judge, in his wisdom, he made it that the teacher, the deputy head, and Mum would all speak about this in front of the little lad in an attempt to rectify the damage which had been done. that meeting went ahead. On the way home from school, the little lad was in tears to his mum saying, "Mum, I'm not ready to play this game yet." So he's still locked in.
Oh.
You know, so the judge's efforts, and okay, he was making an effort to try and rectify the situation. He's not going to be aware of the results, but there is no result. Basically, he's still locked in. Whether or not that will ever be reversed, who knows? But basically, he misinterpreted it, which is our concern with the rest of the curriculum. He misinterpreted it, and it's having devastating effects on him and his family life, because, you know, I think most parents send their kids to school and, you know, they come out of school, "What do you do today?" and blah, blah, blah. And they like to find out, and they, you know, she's missing out on that now, basically, because of a misinterpretation. And like you say, we've got the recording. He laughed it off and made some joke about teaching kids copyright.
So she's missing out. She's missing out on knowing his learning and development in school, and he's missing out on the opportunity to be able to tell his mother something happens in school. So they both,
and obviously, but on a more sort of nefarious side, bad things could be happening now, and that is shut him in. Do you know what I mean? He would never.
He hasn't got that gateway of disclosure now.
No, that's gone. They've locked that up and thrown away the key, basically. So anything can happen to him now in school, and his mum will never find out, because we can sure as hell determine that the school are not going to tell her.
Yeah,
we know they're not going to tell her. So, you know, we've got another candidate now here for potential abuse if the opportunity would ever arise in the future. You know.
John, do you want to say something? I'm surprised it hasn't cut off yet. Do you want to say something before I end it?
Basically, all I'd like to say that if I was a teacher and I was in charge of a child, of this child's capabilities, I would tread on eggshells and try and protect him as much as possible. And it seems that the reverse is the case. This is being railroaded through. Why did they have to contact the Welsh government? Why does the Welsh government have to interfere in such a seemingly insignificant case that should be cleared up at ground level? Why does the government have to that is very concerning as well. And also, teachers do not know, and the head teacher does not seem to know the legislation around this, and he doesn't even seem to know the curriculum that well either, which doesn't bode well for the future. Because if you're talking about a head teacher, how about other teachers in the school? He is ultimately responsible. Garen Jackson actually said, not Garen Jackson, what's his name? That's our local LEA. Jeremy Miles is who I meant to say. Jeremy Miles actually said that the headmasters are responsible for tailoring this curriculum to a special needs child.
Well, the legislation states that the Curriculum and Assessment Wales Act also puts the responsibility, the duty and responsibility on the head and nobody else.
And so does the judicial review.
And so does the judicial review. It's the head. And ironically enough, throughout this whole tribunal, the head wasn't involved anyway. We received no witness statement. There were no comments from. They weren't going to appear as a witness or anything. Everything's been put down to the deputy head, who technically is. Yeah, and like I say, we can show now that the head, at least at some point, was aware that this can be done because of that email from the Welsh government, and we know that the Central South Consortium informed the head teacher as well, and that was admitted in cross-examination in the tribunal hearing as well. So we know full well that the head knew. It's the head's responsibility. It was the head's responsibility to make that determination for Section 42, and yet nowhere to be seen. It seems like the deputy head has been marched out to take any rap. And if there is any harm, then obviously they're liable. They have a duty, loco parentis.
Yeah.
They must treat that child as if the child is their own. basically. So if any
Yeah.
harm does come, then they're liable, basically.
He's a corporate parent in a way, isn't he?
Yeah.
Yes,
Thanks,
basically.
guys. I'm going to wrap it up there. I just want to thank Darren for joining us. Thank Joan for joining us, even though you had sound issues, Joan. Never mind, you got there in the end, girl. Thank you all for watching, guys. This video, keep sharing. I know it's a long one. I will cut it in half and I'll upload it in 2 parts, okay? First part about the legislation, second part about the tribunal. Get out there and fight it. Not all schools are this way, not all local authorities this way, okay? We just need to break through. If you are breaking through, please get in touch. If you have horror stories or you want to make testimonials, what's going on in your life, what's going on in your schools, write it down. We can publish this stuff on our website. As long as we can verify it's the truth, we can keep you anonymous. As long as we can cover ourselves and we know what you're saying is the truth, we can get it out there. But you all need to familiarize yourselves with what's going on now, guys. It is a war. It's a war out there. It's a massive battle, but we are not going to give up. We'll continue rising to the occasion. From next week on, you should see posts for advocacy training. Advocacy training, some of you might find boring, but it's about empowering you knowing your rights, being able to represent yourself, and then we will tailor it with RSE. We'll also tailor some for local authority too. And going on local authority, if you're looking for the guidance on recording that Darren mentioned, on our website, www.publicchildprotectionwales.org, there's a tab local authority. In there, you will find a template letter with the guidance linked, showing you about recording. And also there's a Mackenzie friend guidance there as well. So PCPW is growing. It's growing thanks to you guys. And thank you all for joining us again. Just keep fighting, guys. Keep learning and get this information out there. We're all there for each other. And thank you so much for
thank you,
family, and for everything you do. Nobody knows what you do behind the scenes, but I just want to say thank you for everything. We all know what you do, and we appreciate you no end. To you guys out there, thanks you all for watching. Hopefully you see us. You see more of us now. And yeah, thank you all. Great first show back.
Cheers.
Thanks all for watching.
Bye.
Bye,
Cheers all.
everyone.
Ta-ra.